everything is broken.
Hello and welcome to DadsDivorce.com podcast. Today we're having Ask a Lawyer questions, which we pulled from our DadsDivorce.com website, which you can go on at any time and click on Ask a Lawyer question, submit your question, and we will present it to you in one of our weekly podcasts. Tonight we've got several questions. We're going to try to get through as many as we can. If your question was not answered, please submit it again or send us an email and let us know. Once again, that's DadsDivorce.com. The first question states, my son is 15 and a half. He does not want to pick between us and would like to go live with my sister in New York. We live in Colorado. My wife left and we have not filed paperwork, and she wants to do a fast 90-day divorce so she can marry another guy, and I do not plan on giving in or signing a divorce paper. She said that my son is old enough to choose what he wants. Do you have any advice for the parent for whom divorce is imminent and who has a child near age of consent? Well, I guess the big picture in this question would be what really would be determinative upon what age a child can consent on who he or she would like to live with, whether it be mom or whether it be dad. Depending upon the jurisdiction, I would check with one of your local attorneys out there. Here in Missouri, there's no fine, bright law on whether or not what is determinative upon what child can determine who he wants to live with based upon their age. Being 15 and a half, that would definitely allow the child to tell the court or the judge what he or she, who he or she would like to live with, and the judge can take that into consideration when determining award of custody. One thing that I would suggest to do is I wouldn't try to get a divorce settled within 90 days if there is dispute regarding custody. I would want to get my divorce papers on file and then probably ask for or file a motion for a guardian ad litem, which is another lawyer who will represent the best interest of your child or children. And he or she is really more of the court's eyes and ears and will make a determination upon what the guardian thinks would be in the best interest of the child or children. And what the guardian ad litem will do is talk to mom, talk to dad, and talk to any other third parties or witnesses that mom or dad would want this guardian to speak with. And then based upon that, they'll draft what's called a parenting plan. And in that parenting plan will highlight custodial arrangements, if there's going to be a 50-50 custody, or if there's going to be one parent who will be the primary caretaker and the other parent who will have visitation subject to the parenting plan. And based upon that, the guardian ad litem will submit that to the court as their recommendations to what they believe to be in the best interest of the child or children. However, just because the guardian ad litem submitted the proposed parenting plan to the court, the judge is not under an obligation or duty to go ahead and implement that parenting plan. If the judge thinks that, based upon the evidence that he has heard, that the best interest of the child would be the opposite of what the proposed parenting plan is by the guardian ad litem, then that judge will enact what he believes to be the best interest of the child. Another issue that you may want to take into consideration, which wasn't stated in the question, is regardless of who's going to be the custodial parent, there's an issue of child support that's going to have to be determined. Regardless of what state that you reside in, you're under duty to financially support your child. And what the court will do is it'll take into consideration the incomes of both parties, and depending upon the jurisdiction that you live in will dictate how the child support is awarded. We have a recent book that has been printed by Joe Cordell, which goes into multiple states and jurisdictions and highlighting and outlining the formulas that state follows in determining a child support award. Here in Missouri, we have what's called a Form 14. That was handed down by the Missouri Supreme Court, which takes into consideration the gross incomes of each party. They'll take the gross income of mom and the gross income of dad, come up with what a gross number is for the month, and that is the gross monthly income that family earns. And then it takes that gross monthly income, and depending upon how many children there are, there's a formula dependent upon the number of children that will dictate what that cost is per month for that child or children. Now, you do get credit for health insurance. The parent that is paying health insurance will most likely get a credit for the amount of health insurance. And also there's a visitation credit, meaning that per each overnight that you have your child or children, that will constitute a credit for you. And if you have up to 109 nights overnight per year in the state of Missouri, you'll most likely get a 10% credit. If you have it more than 109, you can get 15%, maybe up to 20%. And that will help lower the child support amount per your child or for children. The next question states that this particular individual has been in the midst of a high conflict divorce in Colorado. There's 4 children, 4 daughters to be specific, 21, 18, and 13. There have been amended final orders as of October 2007. However, per his ex-wife, she decided to appeal the case. The current situation is that the valuation of his business was overstated, and then there has been a drastic turn for the worse in the business, and he will not be able to afford next month maintenance or child support. The terms of the current order have drained every penny from the business, and he may be facing bankruptcy. His attorney cost him over $250,000, and he currently owes $42,000, in which a motion to withdraw was filed. He needs to locate no-cost, low representation to file for a reduction in maintenance, go through an appeal or settlement. Wants to know what his options are at this point, and that what will happen once it's concluded. Now, based upon the question that's presented, if there have been amended orders as of October 2007, the last motion that was filed that hasn't been ruled upon, within 90 days, the order becomes final. So based upon the question, it looks to me as if there's a final court order in place. So what your remedy would be if you were here in Missouri, which may be similar in Colorado, I would suggest that you contact our Colorado office out there in Denver, Colorado. What you'll need to do is file what's called a motion to modify, and what you'll want to do is modify the child support and the maintenance, and that's going to be based upon here in Missouri, it's based upon a substantial continuing change of circumstances. Substantial would be based upon the question that your income has dropped, that your business isn't doing as well as it was at the time that the dissolution was entered. And the continuing change would be that this isn't in a couple months it'll pick back up for sure. That's just speculative, and hopefully it will at best, but in the current situation, you don't know what it's going to be like in a couple months. So that's the continuing change. So the continuing change is the current drop in income, and the substantial change is the drop in income from when the dissolution was ordered. Based upon that, you'll want to include that into the motion to modify. Now, the child support, you want to modify that as well, because you don't want to be under a child support order in which you are unable to comply with, or which takes away more than half of your net income, so you will be unable to pay your reasonable expenses. In order to meet that in the state of Missouri, you must overcome first a 20% threshold, meaning that the child support that was ordered, if it was based upon a Form 14 or based upon the Supreme Court order here for Missouri, then you have to meet the 20% guideline. So dependent upon what your child support was, and in this question here, it doesn't state what the actual maintenance or child support order that is currently in place is. So whatever that number is, there has to be a difference between that number and what you believe that the number would be now by 20%. That's the threshold. Once you meet that threshold, then you can pursue a motion to modify the child support, and the court will take into consideration the change in circumstances, which according to this question would be the substantial drop in income. And so what you'll want to do, at least here in the state of Missouri, under the Form 14 that I was talking about earlier, is put in what you believe that your current gross income is, and then what you think that your ex-wife's or mom's current gross income is, and devise a Form 14 to show to the court there has been at least a 20% credit. I mean a 20% reduction, depending upon what the child support is now and what we believe that, or you believe it to be as you sit here today. You want to get your wife served, and you can file the motions with the court, and then usually the sheriff may have up to 30 days to serve your wife. If you want to get this done expeditiously, which according to the question, that's what it appears to me, you may want to file for a process server. It could be called a motion for a special process server, or there may be forms in the clerk's office at the courthouse in